Okay, that's fine. Design patent, of course, has been a really exciting topic because of Apple versus Samsung, of course. I mean, the 2012 litigation, 2012 trial, established that design patents could be worth a lot of money. Before then, design patents were looked at as like the distant cousin and not worth a lot of money. People look at it like, well, they're like copyrights. You sue people, you get maybe $50,000 or whatnot. In the Samsung versus Apple case, of course, there were like, I believe, 2 utility patents by Apple, and then there were a whole bunch of design patents. Most of the damages came from the design side, and the total dollar amount, I believe they came in at $1.2 billion or $1 billion. Then the judge cut it down to $933 million, which was a humongous number. Design patents, the thing to keep in mind is that the threshold for getting a patent in the design field, the threshold is set very low. Basically, you submit it, and in the 30 years of prosecuting patents, I think I might have gotten like 1 rejection based on prior art. So it's not that the lawyer is very good or whatever, it's because the threshold for getting a design patent allowed in the US, I mean, it's basically whatever you submit, there's a high likelihood that you could get it. So that ties in with an exciting development that, I mean, folks from Hong Kong TDC, HKTDC really should keep in mind, because, can we go on to the next slide? Oh, by the way, the Apple versus Samsung, the next trial is actually starting this week, and Apple is seeking $40 per cell phone, and out of the 50 million cell phones that Samsung sold, that comes to maybe like $2 billion. So that if that comes down, would again be the largest damage award in a patent case. Except that it really shows that the quality of the lawyer really makes a huge difference, in that in a prior case when Apple was disputing similar patents with Motorola, the damage expert came up with like 60 cents per phone. And the new case that they're coming up with, they're now saying is worth $40. So it is interesting to see how they will present it and say that, well, what we said before didn't count. Now, next slide, please. Next slide. Oh. Okay. The new thing that is coming up is that, the exciting thing is that the US finally is going to join the IDR system. IDR system is by WIPO. Currently, it covers most of Europe and most of Africa, but the significant portion is that, the significant part is that Greater China, Japan, and most of Asia is not yet covered. So what it does is that it allows design patent-like applications to be filed. One single application could cover up to 100 designs. Now you think of it. If you file a US design patent, on the practical side of it, if it's like $1,500, $1,700, or $2,000 per design, if you have 100 designs, that's $200,000. That's a lot of money. If you could instead pay 1 government fee and cover up to 100 designs, I mean, that's a lot of savings. That means that even designs that you're not sure about whether or not you could sell or whatever, you just throw it into the application, and that's going to be a very exciting development. Only requirement is that it has to be the same Locarno classification, meaning that if it is a statue, all the designs must be statues. Or since design patents, the law, the US, the way it is adopting the new system is that it is running it through the design patent system in the US. The big limitation is that they are only examining one patent at a time. So therefore, even if you file 100, you have to pick one. Now, that opens up a really interesting opportunity in that with utility patent, think of it, you get 20 years from the date of filing. So the longer you drag on the prosecution, the shorter an effective patent term you have. However, with design patents in the US, the 14 years start with the issue date. So if you have 100 designs in your application and you peel off one of them and file it, your case is still pending. So theoretically, you could keep a lot of designs, pending just by keeping the application alive. That way, you could watch and see what products take off in the market, whether there is infringement before you spend the money and file your divisionals and get that to issue. So how does that relate to trade associations like the TDC? Well, there is an opportunity. We check with the WIPO folks, and basically you are allowed to transfer the rights to an entity that is located in one of the IDR countries. So for example, if a US subsidiary is set up as a holding company, a China company, a Taiwan company, Hong Kong company could have the IP rights in the designs transferred to this US holding company, which could in turn benefit from this system. So right now, the regulations are still being formulated, but it's fully expected that since they already went through a couple of comment cycles, that 2014 is when the system would come into effect. And this really should really greatly change the design patent landscape in the US. Okay, next we move on to trademarks. So what is a trademark? Basically, a trademark identifies the source of your products or your services. And the main purpose for trademarks, theoretically, according to the commentators, is to protect the consumer public so that they're not buying inferior goods or services thinking that it's the real thing. From the business standpoint, business owner standpoint, it is also a repository for all the business goodwill, and it is a tool for protecting your markets. What do I mean? Typically, in the US, in any developed country markets, the business person finds a product that could be worth pennies on the dollar, on the retail dollar, maybe 3 cents, 5 cents. They come up with ginger candies from Malaysia. Oh, I'm just making this up. But I mean, very affordable cost, and then they put on their own brand name and promote it. And the consumer, upon buying this and consuming it, and remembers the good taste, and next time they come back and they specifically ask for that brand. Well, how would they remember how to ask for your product? That's where the brand name, where the trademark comes in. Same thing. Product market differentiation. This is a product that was very, very popular in China. Wheatgrass-based organic wheatgrass health drink. But the thought is, okay, if we come to the US, if we say that the product is made in China, it probably meet with consumer suspicion or whatever. So the concept was that, well, you need to put on a US face. For different markets, you can come up with different brands, different packaging to get the most benefit out of that. And again, the business goodwill after you sell it for and promote it for a period of time would all sit with the trademarks, and therefore the trademarks become more and more valuable. Therefore, in itself, trademarks could be very valuable property rights. For example, Coca-Cola, that mark is probably worth tens of billions of dollars. Next. So what can actually be adopted as a trademark? A trademark is anything that can be used to identify source. Therefore, the typical marks are words, phrases, symbols, graphic designs, and even more exotic trademarks such as sounds, colors, smells, etc. And then there's a class of trademarks called trade dress. We'll address that in a little bit more detail later on. Next, please. So word and letter marks such as public storage. Next. We didn't prosecute this one, but the color of the insulation, paint color for insulation, is a very famous mark. Trade dress. What is trade dress? It's basically what packaging, what clothing your product comes in. It's the appearance of the product or the packaging. That in itself could also be protected. In the, not, go back. In that sense, trade dress as a trademark is much better than patents in the sense that, well, if it's a trademark, if it really rises to the level of a protectable trademark, then it lasts forever. TCO lamp, the example that Sheldon Jeff was giving, they are taking the position that, well, I mean, the appearance is so unique that the consumer just looking at it would know that it's a lamp that comes from the TCO company, and therefore that right lasts forever. Nobody else can make a lamp that looks like that. Patents, utility patents are 20 years from application. Design patents are only 14 years from issuance, so trademarks last a lot longer. However, trade dress, as we go into what is trade dress, you'll see that they are usually unique looking things. The Supreme Court has said that for trade dress, for product packaging and product appearance to become protectable, they have to have secondary meaning, meaning that the consumer really used the appearance as a source identifier. Therefore, when you have a new trade dress that comes out, just coming to the market, you have no sales, no promotion, you probably are not entitled to protection. So it's only the successful product, successful promotional program that produces protectable trade dress. Next, please. Okay, here are some of the more prominent trade dress. The first one, Coca-Cola, everybody recognizes that bottle shape. The next one is the red sole of women's shoes on Louboutin. And the trademark office did restrict it to contrasting colors. Therefore, shoes with a red sole, but if the shoe itself is red, then there is no protection. But if it's white, if it's black, then it could be protectable. The next one is a hard hat. Actually, this is probably the only hard hat company that is still manufacturing in the US. And a long time ago, they have this, since a long time ago, they have this 3-ridge design on the top, and they claim that as a trade dress. And with that alone, they have blocked probably over 50 containers of safety hard hats from Asia over the years. Because, I mean, who would think of, well, what do you mean? I mean, there are ridges on there, how can it be trademarks? The next one most people are familiar with in the Asian community. It is the green cap on the Hui Fong hot sauce. The cap of a bottle could also be a trade dress and a protectable trademark in green color. Like if you go to the sriracha hot sauce. So if you go to the Chinese grocery stores and supermarkets, next time, I mean, just for fun, take a look at see if you see any other green caps. If you do, tell me and we'll go sue somebody.
So may I ask, like, trade dress has to become altogether the color, the shape, all together as the trade dress, or
yes.
just one of like just design or whatever? So say for example, this Coca-Cola, if it's going to be Stella Poon on it, is it still infringing the trade dress?
Yes.
Yes.
Because it's the outside appearance of it. So the fact that you add your own trademark on it may not be sufficient. Well, at least not sufficient for a really, really famous trade dress like that. But most of the trade dress cases that we see really are business owners trying to use litigation to stake out their territory. And oftentimes the trade dress claims are questionable. I mean, we're going to cover that in the US IP culture later on because, well, maybe it's a good time to talk about that too. When you think of intellectual property, okay, when people talk about property, property is usually something that is valuable, you could buy and sell it, and it generates income. Typical, like real estate. But when you think of intellectual property, patents are really wasting assets. Patents are not, I mean, if you spend $15,000, $20,000 to get a utility patent and just let it sit there, nothing's going to happen. There is no income from it. The patent will expire in 20 years from the filing date. The only reason that the patent would become valuable would be if there is business behind that patent. That is, the products covered by that patent is doing well. Same thing with trademarks. Trademarks only have value if you have use of the trademark and the consumer sees a lot of it and therefore ascribe a value to it and is willing to pay a higher price for the products. So in that sense, intellectual property, when you think of buying and selling and licensing, it really has to be tied to, well, what is the underlying business? We're not really talking about property per se, because I mean the property by itself does not have independent value. Okay, next please. Now, this is basically the standard used for all of trademark law. Basically, the trademark office uses this type of analysis for determining whether or not you can register a trademark over the other 2 million marks, 3 million marks that exist currently. There are actually 4 million, but many of them have expired. This is also the same standard used by the courts in determining whether or not there is infringement. From the layman's standpoint, I mean, it's really, the question is, if you put two similar trademarks on two similar products, would the consumer believe that they came from the same place? Okay, that's basically, I mean, distilling it, summarizing it. But the courts typically break it down to a number of factors. Well, how similar are the marks? They talk about the sight, sound, meaning analysis. Usually the first part of the mark is considered more important. And, well, how similar are the goods? If you're selling a statue and the other guy is selling a bottle of wine, there probably, I mean, is no relationship. If you're selling cosmetics and the competitor is using your name to sell, say, a pre-moistened towelette for removing cosmetics, well, maybe there is overlap. And is there similarity in the trade channels? Well, if one is a famous brand watch that sells for $6,000 a watch, and the other guy sells a $15 a watch, maybe the channels do not overlap. How sophisticated are the relevant purchasing public? If it's a $1.50 bottle of soy sauce, maybe the person would not pay a lot of attention and therefore would be easier to confuse. If he's buying a $60,000 car, it's quite unlikely that he would be be confused into buying a competitor's car, thinking that it was sold by Tesla, for example. How famous and how strong is the mark being asserted? Well, Coca-Cola. So if it's really Coca-Cola, I don't care what product you put it on. You put it on underwear, they will sue you, because I mean their mark is so famous. And how strong or weak is that mark? If there are certain words that are very commonly used in the English language, like lovely. Well, I mean there are probably many lovely marks, and therefore those marks are not very strong. It depends on how strong or weak that mark is. One indicia would be, was there actual confusion, such as a consumer buys the infringing products, puts the cream on her face, and then it got red. And she comes back and complains to the genuine trademark owner, and there would be actual confusion. Or if there has been like 20 years of concurrent use, and there has never been report of any actual confusion. We had a recent case in which the client has been using it since like 1976, and the other side sent over a questionable mark, and we told them, what are you talking about? I mean, if there is confusion, I mean, it would have shown up. And the last one is the court. The courts are different on this. Some of the courts say, for example, New York, if there is evidence that you actually copied, I mean, they look at your emails and your internal records, and there is something in there that says, oh, that mark looks good, well, let's copy it, or let's come up with something that to compete directly or whatever. If there is evidence of that, some courts will say, well, that indicates likelihood of confusion. Quite a few of the other courts do not abide by that. Not all of these factors are relevant, but any one of the factors can control. Therefore, you can see that the law is not really black and white. That's why, I mean, it makes predicting sort of tricky. Next. So how do you pick a trademark? First of all, trademarks really serve the business purpose of, okay, I want something that will help me sell 20 million more widgets. I mean, that has to be the ultimate goal. It has to be a mark that serves the business purpose. And then you go to talk to the lawyer, well, can I use this mark? And then from the legal view, you want a distinctive mark, but often clients would come up with words that are really, I mean, descriptive, commonly used, and those from the trademark legal standpoint makes those marks harder to protect and harder to register. Not that it's impossible, but makes it harder. So the classification of trademarks, first, the most protectable are the arbitrary marks. For example, IBM for computers, Google for search engine services. It has absolutely nothing to do with the products that you're selling. Apple for computers, for example. Suggestive marks are things that give you some idea that it may be related to the goods, but it does not describe any desirable quality of the product, such as ivory for soap. Ivory, people think of the image of it being white and maybe clean and smooth. Descriptive marks is where we cross the threshold. Basically, the trademark office says that anything descriptive and below are not registrable. Descriptiveness could come in many forms. For example, you use a name Hong Kong for Hong Kong noodles. Well, I mean, if Hong Kong is famous for noodles, then you cannot register it. It could be a qualitative descriptor, such as crisp for apples. Surnames is also considered a kind of descriptiveness. not all of them, but most of the descriptive marks could still be registered on the principal register if you could prove secondary meaning. That is, the consumers already, you have used the mark for so long that the consumers associate your mark, even though it's descriptive, with a particular source. Then you could register it. Generic marks are things like raspberry for pies, aspirin, elevator, escalators. All of those used to be trademarks. But aspirin used to be a registered trademark. But because it is so commonly used, consumer associate that with the name of the actual product, then it's no longer protectable. Therefore, it ties in with, if you own a trademark, you have to take steps to protect it. Otherwise, it could go into genericness and you could lose it. And how to pick a trademark. Typically, the first step really is to do a screen to figure out, because right now, there are over 4 million US trademark entries on the Federal Trademark Registry. And if you open up the dictionary, there is only, what, 120,000 entries. So if you could pronounce it, the mark is probably taken. That's why before you spend the money on doing your promotional literature and all that, and you really should do a screen and make sure that the mark is available. Next, please.
Can I ask a question? It's like
Please.
Washington State Apple, say for example, is it a trademark? Washington law, where we have like numbers, right? Is that a trademark?
The law basically on geographically descriptive names. Washington State apples, to me, would be a geographically descriptive name. Therefore, I mean, without secondary meaning, it probably is not registrable on the principal register. Washington State apples could become a with secondary meaning, a registrable trademark. Yes, Washington State apples could be a trademark because it distinguishes your products from that of others, like California apples. But there are infirmities in it that they may prevent you from registering it. Okay. Next, we get into an area that, other than patents, actually surprisingly, American IP law, in a sense, favors foreigners. Why do I say that? US trademark law principally is based on use. Before this registration system came into effect a couple of centuries ago, there was trademark law already. Common law trademark. Once you start using a mark in your geographical location, you have priority rights in that narrow geographic location. That's historic, but in the US, basically, that has been incorporated into the statutes also, and that makes the US trademark laws quite a bit different from that of foreign trademarks. In many other countries, China, Taiwan is not a country, but in many jurisdictions, you can register a trademark without use. But basically, in the US, the general rule is that you have to use a trademark, and you have to use it before you could register it. And the general rule is that it's between competing users in the same geographic market, the earlier user has better rights. And trademark rights are not like patents. Patents, once you get the patents, even if you don't use it, you still own the patent. Trademarks, if you, for an extensive period of time, stop using your mark, you could lose the entire right in that trademark. And use is a legal term. It has to be used in US commerce. Merely buying advertising or giving example sales, having example sales, just pack up like 2 pairs of shoes, ship it, that's not considered to be use. It has to be bona fide use, actually taking substantial orders and shipping them. for priority purposes. The last comment here, for priority purposes, the use can be actual or constructive. Filing an application, intent to use application in the US is actually considered constructive use for determining who is earlier. We'll cover more of that later on. Next slide, please. Now, there are basically two types of registrations for trademarks in the US, the principal versus the supplemental registration. For the principal, everything that shows up on your registration is presumed to be correct and presumed to be true. Why does that matter? You think of it. Trademark can last forever. So if you sue somebody on your trademark 65 years after you adopted the mark, it'll be very difficult for you to go prove that, oh, as of such and such a date, I started using it. It's just more difficult. But with the presumption of validity, then it's much easier for you to, the trademark owner, the registration owner, to go prove it. For principal registration, the priority date is set up according to, if it's a registration based on use, then the filing date is your priority date. If it's a registration based on intent to use, then it's also as of the filing date. There are two other types of trademark application. That's where it comes in that the US actually favors foreign IP owners, in a sense, because there are two types of trademark registrations. One is called 44D. It is based on a foreign application, or the related 44E. If you have a trademark registration in China, you can take that without use in the US and actually get a registration in the US. Or Section 66A is the Madrid Protocol. There are about 140 or 130 countries that are part of the Madrid Protocol. And if you file that as an international registration under the Madrid Protocol, again, you can get a US registration without actual use in the US. Think of that. A US company that starts using the mark in the US and cannot therefore file 44D or 66A, he has to actually use the mark before he could register. Whereas a foreigner coming in, if they have a foreign registration, they could base on that and get a US registration without actually using the mark in the US. Another benefit of federal trademark registration is that on the principal registration, you could record the mark with US Customs to block unlawful imports. The US Customs has actually been very proactive in working with trademark owners, hounding them to give examination procedures and whatnot to try to catch infringing products. This was 6 or 7 years ago. We had a client with a couple of copyrights on Christmas light packaging and also one trademark, and we were able to stop 10 or 12 containers just at one Christmas. Litigation advantages, again, with a federal trademark registration, there are statutory remedies for counterfeiting. Counterfeiting means that somebody is copying your mark identically. You can get up to $1 million in statutory damages without having to prove, actually what the real actual damages are. And there are also presumptions of validity. Therefore, the general recommendation is that if a mark is worth protecting, you should get a federal trademark registration. Next slide, please. So like I said, there are four ways to register a US trademark. First is based on actual use. Limitation is that you can only include products on which you have actually used the mark. And use has to be used in commerce. Next is really just a filing. You cannot get a registration out of an ITU. Intent to use application you are basically just telling the trademark office, hey, I have not used the mark on all of the products or services listed, but I have a bona fide intent to use it on those products or services. It's examined just like any other trademark application. However, upon approval, you don't get a registration, you get a notice of allowance, at which time you have 6 months to tell them, okay, now I have used the mark on these services or products, and the registration will only issue on that statement of use limitation. So, and the other two are, of course, based on the foreign registrations and the Madrid Protocol international application. Actually, the 44D and 66A applications are also considered a type of intent to use application. Again, the idea is to get the earliest priority, because trademarks, the battles are often on, well, who is first. Next slide, please. Next. Next. Next.
Should we use this as needed?
Next. Okay, there we go. Use. Again, unlike trademark systems for many other countries, in the US, use of the trademark is absolutely necessary. It's needed to maintain the registration and also for enforcement. The second part is really important. Non-use can be abandonment. If there is a 3 years non-use, it's presumed to be abandonment. And between the 5th and 6th year after a registration, the registrant is required to file a sworn statement that he or she continues to use the mark. And then if he doesn't file that timely, the registration will be automatically canceled. The registration alone cannot support infringement suit. Under the Don Donut case, which has been around for many, many decades, basically the court said that, well, if you have a registration and you want to stop somebody in some locality, that you have to be actually operating there so that the consumer would see both of you so that they could be confused. Otherwise, the theory is that no confusion, no action. Now that sort of restricts, so you have the possibility of suing people, but until you move into their territory, you cannot sue them. That is especially relevant to the foreign registration-based registration in the US. So even a foreign company comes in, registers the mark, they have to be actually operating in where the US competitor is operating before they can sue them. Now, of course, there is a recent Sixth Circuit Appeals Court CarMax case. CarMax, as we all know, I mean, they operate both actual physical stores for selling used cars, but they are also very active online. And the comments of the court was that, well, I mean, this sort of expands on the Don Donut rule that if you're online, maybe that is enough. Therefore, our standing recommendation, I mean, nowadays is that if the client really is selling nationwide or has a possibility of selling nationwide, at least put up a website. At least you'll have some arguments to make down the road if you have to enforce your mark, even though you're not physically in that jurisdiction yet. Next, please.
If I say something like, because the trademark always have some new change, new appearance, so the previous one will expire, or what will happen? Okay,
the mechanical part of it. Trademark office will accept amendments of the mark if the change is really de minimis, is very small. So it's a factual question on what changes do you want to make. So usually, I mean, we've done enough of these. I've done close to 1,000 trademarks, and you show it to me, this is the change, I could tell you, no, I don't think they will accept it, or let's try. Now, if you really have a substantial change, then you're really supposed to register a new mark.
Yeah, because like maybe like Starbucks, maybe at the beginning they have the logo with that the Starbucks on the bottom, and then later on they just have that logo without the bottom, without the letters. So with that, the original one will still valid. Oh.
Again, it goes back to, are you using it? If you don't use it, it could expire.
Oh.
But typically for people like Starbucks, I mean, they're going to keep every single one of their trademarks alive. So they're going to be using it.
Just keep filing it then, right?
Well, they have to keep using it.
Keep using it.
If not nationwide, at least in some of the stores. If they continue to have use, then they could continue to pay to maintain them. Because you never know with trademarks, they come back. Like Coca-Cola, they came up with new packaging, new Coke, and they always go back to the classic, right? So
Yeah.
trademarks are worth a lot of money. Next, please.
For example, this is our latest TDC logo.
Uh-huh.
The original logo is like HKTDC. So we have not been using the old logo for a long time. So in theory, that will be long gone.
Yeah, because like the logo over there, actually, 香港貿易發展局, it will be the full name.
Right.
It will be put full name now. It's kind of like the simplified or the abbreviation on the bottom. So if that one, we haven't used it for a long time, and then it will expire, right? That's so.
Well, you're still using it. You're using that name, the full name, on your stationery and whatnot. So,
No,
I mean,
actually,
no?
it's no more,
Yes.
no longer
Website,
using
yes.
websites too.
Yeah, but the thing is, what we used to only have HKTDC.
It's HKTDC.
It's totally, we don't even have orange color. And
The color is
old one,
like
right?
red, green, and then before there was like.
Yeah, so those one we
gold
don't
color.
use it, then probably we lose it. Is that?
It's difficult to answer the question without looking at all the facts, but typically when we address with clients, hey, if you have a mark that you think is going to be evolving over time, there should be a strategy of, filing it so that it would accommodate that. For example, looking at that mark right there, the whole block, we would probably recommend, well, let's do the logo separately. So next time you change the logo, you don't need to change the whole design. And HKTDC, we probably don't want to file it in color. We'll just file it in block letters with the H and K separated. And theoretically, that would cover all fonts and all colors. So even if you change it later on, you don't have to get a new registration. So it really depends on the facts of the case and what the future plans are. And that's part of a lawyer's job, to sit down with the client and say that, okay, what are the possibilities? Let's go through them. What is the most cost-effective way of doing this? Okay, so how do you use and protect your trademark even after the registration? A trademark is always an adjective. It cannot be used as a noun. For example, so ginger candy. This is Chimes brand ginger candies. This is not Give Me a Chimes. So using the mark as a well, Give Me a raspberry pie. Well, that is probably a generic name use, not a trademark use. So the business owner, the trademark owner, has to be cognizant of that fact in their promotional materials, must use it properly. And when you use the registration symbol R in a circle, you have to use it with your registered goods and services. Otherwise, when you sue infringers, you don't get damages. However, you cannot overclaim if there are products that that are not covered under your registration. You cannot use the R in the circle symbol. And you need to timely renew all your registrations. And any license, any approval for third parties to use your mark must come with quality control provisions. There's a long line of cases saying that if you just allow people to use your mark without caring how they're using it, and without policing, you could lose your entire trademark. And we recommend for most of our clients that for their more important marks, they should put in a watch surface to make sure that the infringers are not filing similar marks that could cause sort of a diluting effect on your trademark rights. And once you know about infringers, you really have to take action, write them cease and desist letters, sue them, go report them to customs, and actually take action. Next slide, please. Trademarks, like patents, are national in nature. So if you want foreign rights, you have to file in foreign countries and get either national registrations or international registrations, such as under the Madrid Protocol. Again, there are situations if the client is a multiple country entity, multinational entity. This especially is relevant because quite a few areas or quite a few territories such as Hong Kong is still not part of the Madrid Protocol. Therefore, you cannot, so to file a trademark internationally in Hong Kong, you need to file them one country at a time. What that means is that you have, say you have 10 trademarks and you have 50 countries that you want to register it in. That's 500 registrations to maintain already. You need just one person just to keep track of that. Whereas if you go through the Madrid Protocol, it could be just one single registration covering all the countries outside of the parent country. So theoretically, for example, TDC, which has a US entity in New York, could have that entity own the trademark. Since it's 100% owned by Hong Kong anyways, you don't think the control is an issue. So one possibility would be to have the marks that you intend to have international coverage, I mean, put that in the hands of a US entity and then have that US entity file the international registration. So there are many strategies that we could explore, so I mean, but they're all fact dependent. That's why you want to go to a lawyer that has actually done this before. Next slide, please. Litigation planning. Okay. We're probably going to address this in more details, but when I said a patent is a wasting asset, a patent is only worth money if there is a market for the products covered, and actually a patent is only worth it if you have the money to actually enforce it. Otherwise, think of it. If you have a trademark, if you have a patent, you have a copyright, and you don't have the resources to enforce it, it's like you don't have the IP. As part, therefore, in the US IP culture, you have to always think about, well, should I just get a trademark? It's more than that. You have to always plan, once I get the trademark, what do I have to do internally, just day in and day out, to make it easier for me to enforce? Down the road, the lawyer asks me for this, I will have it. So litigation planning is related to trademarks would be, you have to save the original adoption papers, especially for the initial years. With US trademark registration, after the first 6 years, you could have incontestable status, which makes it harder for people to cancel your mark. But in the initial years, you really have to save all the original designer invoice, your different versions of coming up with the mark to show that you really, yes, we created it. We didn't copy anybody. First shipment invoices are important. Advertising bills are important. Advertising drafts and things, ideas of how the trademark developed, save all that in a file. And for litigation planning in the US, since litigation is so very expensive, we always tell our clients that you really, this may not be as common in foreign countries, but getting insurance companies to pay for IP litigation is really very important. Otherwise, if you don't have the money to litigate, you're going to lose. The third one is that in trademark cases actually in all of the, well, I'll hold the last one till later. Next. Conclusion. Trademarks can increase value over time. Trademark is like a good wine. It ages, it becomes more valuable, and theoretically it could last forever. However, trademarks are, again, the value is in the eyes of someone who needs the mark. I'll give you an example. A couple of years ago, we have a client that we represented on contingency basis. They've had the registration for over 20 years. I mean, it started basically with the company, but trademarks come and go, and it was not one of the huge trademarks. It was a mark that they were just keeping alive with not a lot of sales. However, there was a foreign company, retailer almost as big as the Gap, that in Hong Kong, China, and most of Europe, and they were trying to move into the US. And we were able to successfully block them through customs and whatnot, and at the trademark office for 2 years. And finally, they came in and said, okay, we'll buy your mark. And so we were able to get the client a new house, and they went for $1.6 million. So a mark, typically we say that, okay, if you have sales in the US, I mean, everybody's profit margins are different, but we say that it's typically worth at least 30 to 50% of perhaps your annual sales at a minimum. So if we use that formula, the mark is probably worth no more than $100,000 to the client. But we were able to get 1.6 for him because the value is in the eye of the guy who needs to use it. I mean, since that's the name of their store, they cannot come in without the registration, and we could sue them if they come in. So.
What's that? The R in the circle and TM
right.
on.
R in a circle is a statutory provision in the US trademark law that says that once you have a registration, you're number one, required to use it, and number two, you could use it. Required to use it, meaning that if you don't use it for the products and services on which the registration was obtained, when you sue people, you don't get damages. So that's the required to. And the second part is you are allowed to use it on products and services on which you registered the mark. If you overclaim, if you put it on products and services on which you don't have a registration, your competitors could sue you for unfair competition. TM is merely a statement, an assertion by the company, by the business owner that, hey, this is my trademark, stay away from it. It has no statutory significance.
So it's not necessary to be registered?
Only the R in the circle is registered.
So if they put TM, that means they have a trademark for that one?
No, that means they think it is their trademark.
So sometimes they may not have filed
right.
for anything.
Mm-hmm.
So can you, okay, patent you can license. Can you license the trade dress?
Of course. All trademarks could be licensed. I mean, a few years back, we were helping a client get a license from Calvin Klein, and you wouldn't believe the terms in there. Yes, all IP basically could be licensed, patents, trademarks.
Just because there was a case that a software company, they put their packagings on one of their software, and that looks like a tie
Okay.
box. It's like the orange and the yellow symbol in the middle, and then with but they were sued by Thai.
Mm-hmm.
Well, they were sued by P&G, and they lost the case, and they paid a lot of money. So if they license the trade dress from P&G, then they might.
Well, with big, huge companies like P&G, the chance of them licensing you.
No way.
Well, you could always ask. You don't ask, you don't get, right? I mean, but it would probably be expensive. But again, in Sheldon's book, he has actually with the approval of the LES Licensing Executive Society, taken the entire chapter from the LES book, which is a huge handbook that sells for over $1,000, I believe. And it's in this book that you have the chapter on licensing. And it talks about you can license just about anything. Because a license is a contract. If there's somebody willing to pay for it, you could literally license anything you want.
I just want to ask,
please.
You just asked us, tell us the difference of circular R and TM. Is it a universal understanding for all or just US?
US.
Only US. So TM in Hong Kong, or say for example,
Hong Kong, you still have the registration requirement. If you don't have a registration, you can't use R.
And TM?
TM, my understanding is, at least, I mean, it's just a claim that I think I own this mark, but it has
so
no.
Hong Kong is like in Hong Kong, in China, it still serves the same. You don't necessarily have to trademark.
That's correct, because with many of the clients who have international markets, it often comes up as an issue because most of the countries, territories like Hong Kong, would say that, well, if you're not registered here in Hong Kong, you cannot use R in a circle. So the lowest common denominator really is either SM or TM. So I'm still making claims that this is my mark, and usually on the bottom of the promotional literature would say that this mark, well, these are our trademarks and they are registered in some of the countries. Next, please. Copyrights. Copyrights is actually a very exciting area. We jokingly call it the poor man's patents. Copyrights cover a very, very wide variety of products. Things like toy cars, soft sculptures such as toys, plush. This is an actual example of one of our clients. Started out in Taiwan, went into China. They now have like 3 factories. And the one client alone has 25,000 designs, every single one of them copyrightable. When you think of that, I mean, for areas like Greater China, copyrights are literally one of the most important area of IP. Copyrights can cover and protect paintings, graphics, designs that, for example, you have the children's dishes or whatnot. It's got graphics on it. All of those could be copyrightable. Fabric designs that show up on shoes, on clothing. Sculptural designs on ornaments, Christmas tree ornaments. Jewelry designs are specifically covered. Photos, music, audiovisual works such as videos, sound recordings, maps, technical drawings, books. Like Sheldon is sort of counting on the royalties on this book to support him in his retirement ages. I mean, we get a small number, a small amount of royalties every year, but it really spreads the name for us. LexisNexis publishes this desk book for lawyers in each of the big states, California, New York, and Illinois. They picked one law firm to be the editor. We've been the editor on this book, California Intellectual Property Laws, which covers both the federal and the state laws. We've been the editor for over 10 years. And we get a small amount of royalty on it. And of course, Sheldon's book is, I think, is actually selling quite well on Amazon. So, unfortunately, it's one of the areas that has not been given a lot of attention, especially in China. The Chinese government has been subsidizing the foreign filing of patent applications, but I haven't heard of any initiative to actually help the manufacturers and whatnot to, number one, I mean, make sure that they keep the right records and whatnot to support copyrights, and number two, to register them. When you think of it, you file a patent application, beginning to end could be $15,000, $20,000. You file a copyright, it is so simple that literally, I mean, for many of our bigger clients, we tell them, okay, even if we charge you a discounted price, it's still too expensive. Why don't you just have somebody come over, we'll teach them, we'll spend an hour or two, teach you how to do it, and you could do it yourself, and then it's $35 per application. You could literally do it yourself. So, but the most important part is that a patent lasts for a very limited time, 20 years from application. A copyright lasts for much, much longer. It's the life of the author plus 70 years if it's individually authored. If it's a company, it could be 95 years. I mean, 95 years is a long time. That's like 5 times the length of the patent term. Okay, next please.
95.
What a copyright protects is original rights of authorship, and it has to be fixed in a tangible medium of expression. Therefore, merely having the idea in your head is not sufficient. It has to be put into a tangible medium of expression. Therefore, for example, if you want to do this sculpture of the Guan Yin, and then you have somebody sketch it up, okay? The sketch itself is protected by copyright. And then after the sculptor takes that sketch and converts it into a derivative work such as a sculpture, that is a separate copyright. Both of them have now been reduced to fixed in a tangible medium, because the first one is a sketch on paper. Second one is an actual sculpture. And copyrights protect against copying and derivation. So it's quite a bit different from patents. Patents, they don't care whether or not you copy, as long as, even if you have never seen that patent before or didn't know that the patent exists, as long as your article falls within the scope of the claims, you can be sued. Copyright, on the other hand, you have to prove, the plaintiff has to prove that there is copying. Of course, copying is such a subjective terms. The courts basically reduce that to less of a subjective proof and say that, well, if it looks substantially similar and there is access to your design, then it shifts the burden to the defendant to prove that they did not copy. So access is easy to prove. If you're selling it in the market, of course there is access. Next, please. So there are many things that are not protected by copyrights. Functional features in machines, functional features in even in a toy. The outside appearance may be copyrightable. What the toy is, the action of the toy is not. Ideas, procedures, and processes could be covered by patents, but not by copyrights. One big area of exception is government work. So anybody could freely use what the US government publishes. Intangible expressions. Michael Jackson comes up with a new dance, but he did not record it. Well, that is not copyrightable. Names, short phrases, slogans, those are in the realm of trademarks, and they're not protected by copyrights. Typically, since copyrights protect text, typically you would think that you almost need a block of text, maybe at least 50 words or more, to pass that threshold. Commonly known symbols or designs, such as you just come up with a star and say that I want a copyright on that. Everybody else who uses a star has to pay me royalty. Trademark Office will say that, well, that's not original enough, therefore that's not protected by copyrights. And since copyrights still have a limited term, Therefore, things that have existed for a long, long time, 100, 200 years, will fall into the public domain, and again, anybody could use it. And there's an area of use called fair use. You could cite the certain literature and run a critique on it. That's not in itself a copyright infringement, but that's a convoluted area of the law.
Just
next, please. Please.
Gangnam style dance, so everyone knows it. So is it a copyright here? And second, like there are people on YouTube doing all this Gangnam style dance again. Are they infringing the copyrights?
If that dance was actually recorded, all right, that theoretically, if it's reduced to a tangible medium, it's like choreography, and you reduce it to a video, or
it's like a music video on MTV channel.
So theoretically, it is enforceable, but the question is, how are you going to go around the world and sue 100, 200 million people?
Copyright by itself.
Yes, choreography is specifically provided in the law is copyrightable. Okay, next, please. So term of the copyright is much longer than patents. Life of the author plus 70 years. 95 if the author is a corporate entity, partnership, corporation, etc. We have jokingly called the copyright law in the US the Mickey Mouse law, because I mean copyright term used to be a lot shorter than this. It used to be like 26 years and renewable for another 26 or whatever, but it was never this long. It was like the lobbies from the film companies and whatnot, like Disney being one of the most prominent ones, keep asking Congress to extend the terms. So from the standpoint of other countries, I mean outside of the US, people have to think about, well, if that is the law and we cannot change it, they have to think about, well, how do I make better use of this? And for Greater China, I mean, it's not for the lack of materials. I mean, Greater China is literally one of the biggest, if not the biggest, powerhouse in copyrights, because copyrights are created once you have the work done. You don't need a registration. Okay, next please. Now this is yet another area in which the US IP system actually favors the foreigner, right? The first item there, work for hire. The US law is different from a lot of the other countries in that there's a concept of very broad concept of work for hire. If you hire somebody to work on something within the scope of employment, anything copyrightable created by that worker automatically not just belong to the company, but has the company itself as an author. When you think of it, a company is like not a real person. How can a non-real person create anything? But that's the legal fiction, that if the employee worked on that piece of work and is copyrightable, then the company itself is the author. That is not the law in many of the foreign countries. In the US, another big area of difference is derivatives need authorization of the owner of the underlying work. France, for example, has a very different rule. It basically says that you can take the work of anybody else and then just make changes, and the changes are yours. You could have, if the changes are big enough, you could have an independent copyright in what you changed. However, the US rule is that if you want to do that, you need the authorization of the original work, the owner of the original work, before you could do that. Otherwise, you cannot assert your copyright in the derivation. The third area is that for a work authored in the US, you must get a registration before you could sue. So again, if you cannot sue on something, it's like you don't have the rights. The difference is that if the work is created in China, outside of the US, then you don't need a registration. You could sue on that directly. But of course, registrations has other benefits. Next slide, please. In the US, after you get a registration, again, you get a presumption, multiple presumptions. Number one, that whatever is stated in the registration itself, that you're the author, that the work was created as of such and such a date, first publication is as of such and such a date, all of those are presumed to be true. And if you register it within, that is true only if the registration was obtained within the first 5 years of publication. If you wait 10 years later, then there is no presumption. Every time you sue somebody, you have to go in and prove that you actually created that thing. That comes in especially as a problem for foreign creators because they are not used to the US litigation system. They don't keep good records. So come time to enforce their rights, it may be very difficult for them to put together the files, and that is one area, for example, that a trade association like the TDC could spread the word and make sure that members and manufacturers really could keep good records, since it does not even require registration for them to assert their rights. And with copyright registration especially, there are statutory damages that are very substantial. In copyright cases, typically when you have a statute, the people you sue could be retailers selling maybe 50, 100 of these on eBay. So we're not talking about huge damages. That's why statutory damages would come in. And you could just say that, Judge, I won $100,000 in statutory damages. I don't care what his damages are. And with copyright registration, you're also entitled to custom recordation of the registrations. Okay, in this 21st century, of course, we're expanding copyright coverage to many of the things that we see online: web pages, graphics, photos, videos, music. And copyrights also cover blogs and emails. And privacy and data ownership is a fast developing area of the law. There are new cases reported almost every month. Next, please. One of the areas that comes up under the DMCA, most of the online retailers now will have a takedown provision that you, as an IP owner, you could go in and tell them that, hey, this guy is copying my copyrighted work or is using my trademark, and demand that the infringer's page be taken down. However, there is potential exposure for wrongful notices. We recently had a case that the client went in on copyright notices, and the other side actually took action and sued first and said that our DMCA, well, we didn't file the notices, the client did, but they said that the notices wrongfully accused them of infringement and that the copyrights were no good. And good thing that our client has insurance to cover that. We're going to go into insurance later on. And other area that is important in the new age is that there is Creative Commons is more and more coming into play. There is a lot of software and software tools out there. Most of them, you could use them. However, they come with licenses that says that whatever you create, the derivation that you make from it must also be open source. Therefore, that's totally contrary to the purpose if you want to develop something and sell it. So a lot of care has to be taken if the client, if the business owner wants to use open source software. We typically say it's probably not worth it. Since you could lose both your copyrights, and there's some case law that indicates that you may also lose patent rights because you have to look at the Creative Commons agreement that comes with the software. Next, please. So how do you avoid copyright infringement? Well, do not copy. And not only do you not copy, you have to show that you are independently creating it without having access to whatever you're supposed to be copying. So in many situations where you already know about a competitor and you want to stay clean, we would help the client with coming up with a clean room construction, basically coming up with procedures so that their creative team is isolated from the rest of the operation, and make sure that there is no access to what is problematic, and where necessary, try to get the licensing required.
Can we suggest, should I suggest, like before we go to training,
sure.
we can have 5 minutes?
Please.
For everyone? Just for 5 minutes? Okay, thank you.
Do you want to control it?
Come ahead. Okay. Welcome back. The next topic is trade secrets. Other than patents, trademarks, and copyrights, this is probably the most high-profile area of the IP law recently, just because of the several big high-profile cases, like I believe it was DuPont, the white pigment case involving the China manufacturer, and a number of Chinese nationals or Chinese Americans being involved in high-profile trade secrets case, such as I believe there was a recent one in which a Chinese national came to the US, was hired by a trading house, and the claim was that he tried to steal the trading protocol and whatnot, the trading system, and he is currently being prosecuted in New York on trade secrets. Trade secrets are basically up to this point mostly state law. And the term trade secrets is defined under state statutes, so there is no uniformity as to what is trade secrets. Even the federal laws that attempt to come in still mostly rely on state definition. So depending on where the act is done, the laws could be slightly different. Usually it requires generally conscious efforts to protect. Is one of the more maintenance-intensive IP in the whole spectrum of intellectual property. And it is likely that we'll see a lot more enforcement in this 21st century. For example, California defines a trade secret as information including a formula, pattern, compilation, program, device, method, technique, or process that has independent economic value from not being generally known to the public. And second requirement under the California definition is that it must be the subject of efforts that are reasonable. So whether or not the efforts are reasonable is always part of the litigation and enforcing trade secrets. Reasonable under the circumstances to maintain secrecy. So what is reasonable? Well, if you file a patent, then it's laid open, it's no longer a secret. So restricting access is the most important. For example, if you have a computer and you have databases, you need to have passwords. You can't just allow everybody to access them. And you have to, if you have a program for maintaining trade secrets, you should document that, put that in the company operations manual or employee manuals. And for the contractors, for outside people, you should have NDAs non-disclosure agreements for all of your employees. Of course, I mean, the expectation is that there should be employment agreements providing for who has access to what and what they can disclose and they cannot disclose. And if you're going to entertain visitors, visitors should really be limited to areas in which there are no trade secrets. This applies especially if you have a factory and you have a trade secret process. You probably don't want to take them down there. A good example would be if you have a, say, if you have a noodle factory and the ingredients in the particular noodles, how many pounds of flour, how many pounds of soda or whatever. If that is important, certainly you don't want other unrelated people in the work area where you're measuring out the quantities. The common risks in maintaining trade secrets is that oftentimes you could lose your trade secrets through inadvertent disclosure. Many big companies, especially, they like to publish white papers and publications just to, I mean, get a name for their staff. And you go to conferences and typically before you go there, you need to have patent counsel, the IP counsel, to vet your papers to make sure you're not disclosing things that you don't want to. And don't talk, I mean, don't have loose lips when you're going to social functions, disclose things inadvertently to friends. Since a corporation, a business deal through employees mostly, the handbook, employee handbook, must have policies covering trade secrets, how they're handled, especially on the fact that the company does not want to use the trade secrets of others, and you have to enforce that within the entity. And the employment agreement, again, have to cover all of the issues that are identified. And because in recent years, there has been more and more high-profile, high-value, I mean, claiming damages of tens, if not hundreds of millions of dollars through trade secrets. It is important, I mean, some of the cases indicate that one of the factors showing that, I mean, the guy really stole trade secrets was the employment agreement expressly said that you are in this job, you're not supposed to learn certain areas of the job. I mean, if they're really sensitive stuff, they now actually write that into the employment contract, and down the road, if you find his computer, it shows up on his computer, this is not things that you're required to have. This is actually a newer development, so there'll be a lot additional drafting required. You have to analyze each of the employee coming in, and I mean, if they're really sensitive areas that you want to block them from, you have to expressly provide for that in the agreement. And you need to educate the employees to be sensitive to trade secrets issues so that the entire organization could act as one. What is more troublesome is that trade secrets is also getting to be a political animal, with the enforcement and really sellers, some say overzealous enforcement of the Economic Espionage Act, Federal Trade Secrets provisions, and the Computer Fraud and Abuse Act, which has been around forever, but that only applies to unauthorized access to computer data. At least the more high-profile cases seems to be directed a lot to Chinese nationals and Chinese Americans. Maybe it's just the fact that we're Chinese Americans, and therefore when we read the Chinese papers, they only report on those cases. But it does seem to come up with quite a bit of frequency. The Federal Economic Espionage Act basically has two sections. 1831 provides $500,000 in fines or 15 years in jail. If it's a corporation, then it's $10 million in fines if a government instrumentality or agent is involved. So you're stealing the trade secrets to try to benefit a foreign government. Now that really, I mean, with many of the, at least in Greater China, you still have a lot of SOEs, and the law is not entirely clear as to whether or not those are a government or instrumentality of the government. Therefore, it could be troubling. It really behooves companies from Asia to really be sensitive to these issues to stay out of trouble. (1832) is, if it does not involve a foreign government entity, then the fines are lower, but I mean it's still like 10 years in jail, which is a very significant penalty. So that concludes trade secrets. So far we have covered what is intellectual properties, basically patents, trademarks, copyrights, and trade secrets. Next, we're going to go into the more general discussions. If you want to make good use of U.S. intellectual property, you have to understand the culture. Understand the culture, not only the U.S. culture, but also the legal culture surrounding intellectual property. The U.S. is still probably one of the biggest export markets for anybody in the world. So for foreign players, they have to come in, and if they want to be involved in the trade, in the business, they really need a better understanding of the cultural background of the U.S. IP system, and watch out for things that especially apply to foreigners. And okay. Rule number 1, thou shalt not lie. The entire U.S. legal system is built around the expectation that people who do business with the government, at least, have to deal in good faith. Government includes the Patents, Trademarks, Copyright Office. Government includes especially the courts. When you're within that realm, when you're within that circle, you have to be very careful, and you cannot tell lies. Now, that really is not just it is every single layer of administration. If you go to customs and you tell lies, the consequences are much, much higher than just I mean, that one shipment, they put you on a blacklist, and then they could do very bad things to you. And untruthfulness, withholding information, or bad faith when you're dealing with government entities could carry very serious legal consequences. And they could far exceed the economic value of the property. Well, is it because Americans are more honest? That's why they say you cannot lie? I don't think so. It's really because we're operating in a free market, and we all know that capitalists like to puff. I mean, if it's one, they'll probably say, oh, it's 3, and I own 16 factories or whatever. That is fine. People expect that when you're dealing businessman to businessman. However, any time when you're, because the system gives you more benefits if you register your trademark, and therefore when you deal with the government, you cannot tell lies. Plus, you must be able to enforce your IP so that it would have value, so you have to be very careful in doing litigation planning as to how to stay away from problems. With regular business dealings, people know that you're going to puff. They know that you take whatever you say with a grain of salt, but any U.S. government or state government will expect that you are totally 100% honest. So the red line is that any conduct before the various government entities, the legislature, for example, if you're dragged before Congress, you cannot lie. and administrative meaning the various application bodies and the judicial, the courts. Everything must be based on truth and good faith, and cannot be based on substantial falsehoods. There are express statutes, 18 U.S.C. 1001. If you make knowing false statements, it could be punishable. Before any of the executive, legislative, and judicial branches, you could be jailed for 5 to 8 years. Although that law has not really been used a lot, unlike the trade secrets laws, but it's there on the books.
So that means if they claim the false statement before trial, they can be already put into jail for 5 to 8 years. Is that what it means?
Theoretically, if you lie before Congress, for example. Okay, how does it come into play? I have an example of a specimen submitted by a Chinese company for a trademark registration in the US. All right? So we looked at it and we laughed, and we filed a cancellation proceeding. And well, if you look at it, the trademark is California Beef Noodle King. All right? So they submitted this as an example of a 1-year anniversary poster that they were passing out or posting on their premises. So if you look at it, it says, "Ladies and gentlemen, peculiar spicy chicken, dish, California chicken with exquisite dishes for free." Well, I know of no fast food restaurant that you would come in the door, they'll give you anything for free. Second, curry and rice, noodle and beef tendon, US dollar $25. I think they got it mixed up, they thought it was renminbi.
Yeah.
A bottle of mineral water for clients who spend more than $45. I was like, okay, well, you're going to lie at least. Lie convincingly. So, obviously, we filed the cancellation, and the other side didn't even bother to show up, and we canceled the mark. Now, a very important part of intellectual property planning is planning for litigation, because in the life of most IP, you have to plan for litigation. Therefore, every single step is like if you try to do it years later when just before litigation is way too late, because the necessary documents would not be there. It's more like there has to be a corporate culture that all the people have to understand, well, what do we need to keep so that in the future if we need to enforce these things, we would know where to find them. And everything has to build around how do I ensure that in the future, if I litigate, I would have the necessary support. Again, the court systems, really, it's like they put a lot more value. The court is supposed to be neutral, right? They don't take a position. Party A, Party B, civil case, the court judge could care less who wins. So what they stress is that the system's integrity is the most important. If it shows up that one of the parties is lying, the judge is going to do very bad things to them. If you litigate, one side wins, you lose money, one side wins money. But if that party engages in perjury, in lying under oath, the person could get thrown in jail. Moreover, the court could, because of such misconduct, rule that on many levels, the judge could rule that you lose that one issue, judge could rule that you lose all your defenses, judge could rule that you could lose the entire case, including your counterclaims. And we've seen things happen with that. With most of these big deal patent enforcement and whatnot, they are usually constantly, accusations of misconduct on both sides, and sometimes it sticks, and the judge could fine the parties or the law firm hundreds of thousands, or if not millions of dollars. So part of the planning is that with IP, since they're created by real people, So when you go into litigation, who can be the witness? It's usually the people who are involved in the actual process that could be the witness. And typically the bosses, 领导, they don't want to show up in the lawsuit and testify. So if he doesn't want to go there, you have to think of, okay, in the future, if I have these copyright things, who is going to be testifying, and maybe be nicer to the person and not have them leave in 2 or 3 years and you have nobody to testify. And you cannot really, you cannot defer that until the litigation comes up. You have to plan it from day one. And each business should really have a litigation officer. It could be the boss himself. But you have to think of, okay, in the future, if I have to defend this, if I have to enforce this, who is going to be testifying, who would be keeping track of all the documents so that when I say go, I know where all the documents are. Discovery. The American litigation system has one thing that is really different from most of the systems around the world. There's very, very expensive and extensive discovery. Basically, there are 4 levels of inquiry that a litigant could ask the other side. First is a written question, interrogatories. Second is they could request the production of all documents that could possibly lead to things that are relevant to the case. Third, and they would send formal written requests for admissions so that you don't have to try the issues. And 4, they could drag the parties and other witnesses into a deposition in which the person is asked to answer questions under oath. Again, telling lies under oath could have ramifications far beyond the actual civil case, and therefore expectation in the US system is that if you go to a deposition, you have to tell the truth. Then it's up, but you don't have to answer questions that are not asked. So the skill of the lawyer asking the questions would be very important. But if he asks the right questions, you have to answer. Therefore, I mean, deciding who is going to be testifying is actually a very important part of the planning. If the person really does not have the same interest as the company, it could turn out that he or she may be saying things that the management would not like. Okay. Now, why would, I mean, this is not just with Greater China. We've had, one of our partners was talking to Swedish counsel a while back, and the lawyer was asking him, why are the lawyers on the other side questioning my witness? Don't they trust him? They were laughing. I mean, of course they don't trust him. And it's like, while there is no duty to voluntarily divulge information, but if the opposing party makes requests and asks questions, you do have to comply subject to objections. And destruction of evidence is generally criminal under both federal and state law rules. Hiding information could also lead to sanctions up to losing the case. And it's not just the parties, and the lawyer could also have exposure, could lose his license. Legal hold, especially with electronic mail, electronic file maintenance being an important part of most business operations in the 21st century. The law is developing very rapidly with respect to, and there are new professions being developed that specifically deal with legal hold. What is legal hold? Legal hold basically says that once a party is reasonably knows that there is a foreseeable legal claim, then there is an obligation created to retain and not destroy evidence. And that is especially troubling with electronic files, since it's so easy to delete things, and people usually, many businesses, small businesses especially, they go in daily and delete things that they don't need. Once they deal with the issue, they just delete them. Well, if you're in litigation hold, you know that somebody is going to be suing you, no longer can you delete things. especially electronic files. And failure to observe legal hold could lead to very serious sanctions such as fines and defense exclusion. You can no longer maintain certain defenses or even lose the entire case. Documentary evidence, again, I mean, this is part of the planning, since a document is worth a lot more than life testimony. So therefore, to the extent possible, you need to keep documents that are favorable to your case over the years. And this is, again, not something you could do after the fact 10 years down the road. It has to be part of the corporate culture to keep files and records of things that might be used in litigation in the future.
Right now, like, because like the patent and trademark, like, they can trace back to so many years, but for usual corporate, in a way that we keep things like 7 years or 10 years. So what's suggesting you have to keep all the way back? Like
7 years or 10 years is typically for accounting documents and tax documents. For some of the things, you really have to go all the way back with things like Evernote. Is really not difficult to just scan everything into your database and just keep them there. And especially when your company is sold and you transfer ownership, you need to transfer all of that. So we go into the different areas. In the patents area, of course, you keep all of the lab notebooks, because at least under the old law, first to create, I mean, first to invent has superior rights, and where the tail end of it, the new law came into effect just a little bit, a year or so. So, I mean, the old law, there is still a tail end. You still need the lab notebooks to prove, I mean, the earlier creation, and any sort of invention disclosures and how they were changed over time. All of those should be saved. I mean, they should never be disposed of. Internal memos and monthly reports and lab test results, all of those things, because a patent could be worth hundreds of millions of dollars or more. I mean, and in litigation, if you have to really go back and prove, okay, there's a 6-month difference in time of invention, then, I mean, merely having somebody stand up and testify isn't going to be convincing as having a lab notebook with a date on it with two witness signatures. So there are certain types of documents that you really have to maintain. Trademarks. Design files, especially including all the trademark searches, should be kept to show that you adopted the mark in good faith. You're not trying to rip off anybody else. And the evidence of earliest users, that is one area that, I mean, oftentimes in litigation you cannot find. So if there are early invoices, shipping documents, whatever, at least keep a few of them in the file forever. And in many of the cases in which the registrant is being aggressive and put down a lot of products, I mean, we have litigated quite a few of those cases, asserting that there was overclaim because I mean, they list 62 different products, and it's clear that in the market you could only see them selling 2. So that could invalidate their trademark, and therefore if you really have a lot of products identified, you have to keep for each of the products showing that you have actually used the mark. And over the years, if you want to prove secondary meaning, if it ever comes into play, you need ads and the costs involved in the advertising to show that you spend a lot of money in promoting the mark. For copyrights, especially for foreign companies, since many of them do not have registrations in the US, although I think that is one of the areas, for example, the TDC could help the Hong Kong and the Chinese manufacturers do, is to really promote, hey, copyright registrations is only 35 bucks. It's a crime not to get a whole bunch of them. But for those who do not have them, when you go sue people, you have to prove that you're the first to create it. So the creation file is very important. I mean, if all you have is this, how would you be able to stand up in court and say that, yeah, 10 years ago I already created this, and he copied me, right? Otherwise, the other side is going to say that, I've never seen this before, how can I copy you? If you have molds, if you have original drafts and whatnot, for the molds, at least take a picture of it if you don't have space to keep all the actual molds. And another important part is that with the U.S., the law is quite a bit simpler because, I mean, you have the work for hire. Employees work, basically the corporations work. The corporation is the author, but for many of the foreign countries that is not the law, in which case it would really require that the company have proper contracts with all the employees to say that, I mean, you could certainly provide it by contract that all the copyrights in works created by the employees belong to the company, but you need to have those contracts in place. Again, it's a question of education. Most people don't think of it until it's litigation time, and that's too late. For trade secrets, again, you need to keep track of course, defining what the trade secret is. So you need the files related to, I mean, describing what the trade secrets are, and there needs to be evidence showing the procedures and the efforts taken to protect the secrets. Company employment manuals change over time, so if there are different versions, you have to keep them to show. Since trade secrets, again, as long as you keep it secret, it lasts forever. So it could be over a period of several decades or more. So if they're changing policies over time, you need to keep copies of them. Again, at least keep electronic copies of them. Now, another part of the U.S. IP culture is that in litigation, you have to recognize that there is only one trial. In quite a few of the foreign systems, especially in China, you can go through a first trial. If you don't like it, you go on to the second panel and you get the case tried all over again. In the US, basically, the appeals courts only deal with the procedural and the law issues. They cannot retry the facts. In any case, you have the facts, you have the law. So the appeals courts typically could only challenge the underlying court, the trial court's decision with respect to the law and the procedures, but not the findings of fact. Therefore, you basically only have one chance to present the evidence to prove your facts. And in the US, the courts are a little bit more diligent in enforcing judgments. And fraudulent transfer, I mean, by the time you have been sued, it's too late to transfer assets, because fraudulent transfer itself is a criminal offense, and it's got a very, very broad conspirational type net that anybody involved could be dragged into this, the lawyers, the accountants. So, I mean, the professionals are cognizant of that, and they won't touch this if you ask them to help you hide the assets. Therefore, in litigation, it really is very important to take your best shot during the first trial. In dealing with the other administrative bodies, such as the Patent Office, Trademark Office, and the Copyright Office, you cannot lie. You're required to tell the truth, often under oath. And the minimum is that it could, if the facts turn out to be untrue, it would impact your ability to enforce. Again, going back to the example I give, I mean, this would be lying in the files, in the government's files, and you cannot change it. You can, I mean, it's like an infirmity that you cannot correct. Next, we turn to, I mean, okay, you have, I said earlier, IP patents especially could be a wasting asset. Well, you think of, the US now have 8 million patents, but how many of them are actually commercialized and how many of them are actually enforced? Only a very, very tiny amount, because patent litigation is infamously expensive. The current wisdom is that it takes, for a real patent case, it's $2 million and up. That means that most smaller or medium-sized entities simply cannot afford to enforce patents. First of all, they don't understand the system, especially for the foreign companies. And to register the patents, I mean, It is costly. I mean, for $10,000, $15,000, $20,000. I mean, multiply that by 10 or 20. There's a lot of money for smaller companies, and litigation cost is very high. And typically, it's rather often actually one of the bigger infringers are your biggest customers. So how do you do that? How do you sue your biggest customers? They cut off your orders, and therefore, I mean, it requires additional planning. If you can't enforce your IP, that's like not having IP. But luckily, there are a number of smaller, the big firms typically don't do it, but there are a number of smaller IP law firms that do contingency, such as our firm. We do contingency work on patents, trademarks, and copyrights. But since it's ran like a business, we're very, very selective. We only pick the good cases. But at least there is the additional avenue. If the smaller players don't want to spend their money, go talk to a contingency lawyer. Okay, next we go to contracts. Contracts in the IP area, well, contracts are voluntary transactions. So you have two parties, they sit down and say that I want A, you want B, and you come to a compromise. In the US, the most important business agreements for smaller size businesses, well actually for just about any business, would be the employee agreements that provides for confidentialities, trade secrets, and assigning all of the trademarks to all of the IP to the company. And that also applies in a more abbreviated version for contractors. Next would be the NDAs, the confidentiality agreements when you deal with outside companies, be it customers or suppliers. And standard terms of and conditions of sale and purchase are also very important, especially in states such as California that have all these crazy, imposition of things like CLRA and Prop 65, and it's like almost impossible not to run into these cases. And therefore, as any business, you certainly want to pass the liability and responsibility upstream to whoever is providing you with the products and services. And for companies that have shareholders, you want operating agreements, shareholder agreements. And if you have, nowadays everybody has a website, so there should be terms of use and privacy policies. Again, in places like California and New York, there are particular state law rules that apply to if you have users that are minors. They want additional language, so things to watch out for.
So is there like the terms of use privacy policy for websites already applicable to like the mobile devices, like the apps and whatever? So right now, how extensive when you write the terms, is it protected already with the mobile apps?
That is more from the standpoint of if you maintain a website, if you have an app online, that it should, both of those should specifically provide terms of use and privacy policy right there, so the consumers would know what to expect. Again, in the US, it's mostly a disclosure system. So the theory is that if you tell them this is what it is, the consumer could elect not to participate. Okay. Next area about contract is that, this is standard supplier contracts of big firms like Walmart, like Home Depot, like the big firms. They have this standard vendor agreement that, of all the ones that I've seen, they're very oppressive. Basically, they will say things such as, all your trade secrets, once you tell them to me, they're no longer secret. I can use them any way I want. Anything that's my trade secret remains a trade secret. Plus, there are many variations of these. They say, after I buy from you for a period of time, 2 years, 3 years, I'm free to use the designs. I could basically go with anybody else. And because they're so big and the smaller vendors are I mean, basically, they don't have the bargaining power to change those. Either you sell to them and, I mean, follow those rules, or you don't get the sale. So that on several different levels. I mean, it's not something that the suppliers could deal with themselves. But I mean, it's certainly government entities or trade associations, if they think that it's worth the effort. I mean, certainly governments could come out and say that, well, this type of contracts are not enforceable, and that, or even at least have an educational effort to make sure that the vendors understand that, hey, this is what you're subscribing to. There are ways of getting around it. For example, if they say that, well, after I buy from you for 2 years, I have the right to use. Well, that's only true if I own the IP. What if the IP is owned by somebody else, another entity? I mean, so there are ways of dealing with it, but if you don't know what the issues are, you're not dealing with it. Okay. Next area, this is one of the more important areas from the standpoint of a lawyer. Because when you have a client who wants to protect all his rights, but he said, well, I don't have the money to pay for it, well, you don't really have a client. So in the last 30 years or so in the US, a lot of the IP litigation has been funded by insurance, because most of the older insurance policies in the commercial general liability coverage area, that theoretically you could find coverage for infringement lawsuits. And big insurance companies have been trying their darndest for the last 30 years to write that out of their contract, with some success. I mean, the big four, I won't name names here, have been very effective. Basically anything IP they're excluding. But many smaller, especially out-of-state insurance carriers, still have what is called the ISO policies, the older policies, that you would still be able to find coverage for that. Therefore, if it's likely that the business could be involved in IP litigation, I mean, having adequate insurance is really very important, because if you don't have the money to defend yourself, you're going to lose. There are different types of policies. For example, the media coverage policies, that at least the commentators are saying that the coverage is really very broad, and people were wondering, the lawyers are wondering, well, can that be extended to cover not just the advertising agencies, but also regular businesses? So they're all fact-driven. So I mean, if the client thinks that he may be involved in litigation, insurance planning really is a very important part of that, because getting the carrier to pay for it is very, very important. And oftentimes it means whether or not you could settle the case and go back to business, like the DMCA wrongful notice case that we had. Not only were we able to get money from the infringer, we also get the client's insurance company to chip in money to help us settle the case, so that the client end up with all that money. Because from the standpoint of a lawyer, we don't really care where the money comes from. I mean, we just want to make the client whole. And part of that is getting the right insurance contracts. TDC, what can TDC do? TDC is such a wonderful trade organization. You serve over the years really admirable position of educating all your members, the industry, and you're facilitating trade flow. I mean, kudos to you. I think right now, I don't know whether there's a systematic provision for making resources available, government resources, and the professional lists, whatnot. In terms of helping the industries, for example, there are certainly things that government-like entities could promote, like pushback against the big foreign companies' contracts of adhesions, so that everybody is on more of an even playing field. And even, especially for Hong Kong, I would think that there's great opportunity in working on helping the formation of IP pools, not just in patents, but especially in copyrights. Because think of it, one factory, well, one company, 3 factories, 25,000 designs. I've never heard of a Chinese company, maybe Huawei, that's got 25,000 patents. Copyright is a lot easier to get, and they last forever. And if you think of it, if you could get the few key pieces around one sort of fabric design or whatever, that could in itself be a ongoing business. You basically go down to the retailers and Walmart or whatnot and tell them that, look, I mean, this is our portfolio, what do you owe us this year? I mean, that could create a lot of revenue flow through Hong Kong, and you could help with the competitiveness of the manufacturers, because the trend is that low-cost manufacturing is moving away from China. So the MADE, made in China, is, first of all, is, I mean, not as big because less things are made in China. So you cut it, separate it into manufacture and design. The design should still be worth a lot, but no steps are taken to protect them. So TDC could certainly take the lead and do more things in that area, I hope. Okay, Sheldon threw in those quotes. Everything that can be invented has been invented. That was in 1899 from the U.S. Patent Office Commissioner. What did the fool know? Heavier than air flying machines are impossible, said Lord Kelvin. Kelvin, the degree Kelvin was named after him. Well, tells you what he knows. Who the hell wants to hear actors talk? Warner Brothers used to make like silent movies. So the law and the IP is developing very, very rapidly. So we hope that we have touched on how to take steps to protect various types of IP, and especially when to call in help, to know enough about the issues, to call in the lawyers. And with that, we also have a free gift. It is an online application that we provide for free. It's a meta search, quick search tool called ipscreen.com. All you have to do is to type in the name of the entity, and in a few short seconds, hopefully, it will come up with all the patents, trademarks, and copyrights of that entity in the US. And I know of no equivalent of that up to this point. So that concludes our presentation. If you have other questions. Or we're all going to both lunch.
What is the insurance? Is it like, because like trademark and everything is like so big, it takes time. How will the insurance company try to accept that kind of premium services? Is it like
they don't?
You file and everything like already done that you will be able to go to the insurance company to like, I want to buy this insurance coverage? That's this question.
This day and age, right, it would be very, very difficult to buy defense insurance, saying that if I get sued, I want to be covered. Mm-hmm. There are portfolio policies, but the expenses are very, very high, $100,000 in premiums and up. And what we were talking about was just the common general business liabilities, CGLs, comprehensive general liability coverage that most businesses would have, and it costs them a few $1,000s a year. It's something that you keep, and when you're sued, then you go to the lawyer and look at, well, do I have coverage? If you ask the insurance company, if you ask the insurance agent, they will tell you, no, there is no coverage. Are you crazy? Your litigation could cost hundreds of thousands of dollars, and you're paying only, what, $3,000, $5,000 in premiums a year. How could there possibly be coverage? But keep in mind that a insurance contract is a contract of adhesion. What that means is that, at least under California law and most state laws, is that if there is any ambiguity, it's construed against the carrier. And therefore, it's the job of lawyers to find those ambiguities and tell them that, aha. I mean, for example, a lawsuit may have 16 different claims. Under California law, at least, all you need is one. And then they have to defend the case. So it really is to be able to find the right professional to help identify the issues and help the client look through their policies to make sure that they are covered. From the planning angle, I mean, again, you want to review the current policies and make sure that, I mean, they have coverage. Plus, another thing is that insurance documents is one of those things that you want to keep forever, because most CGL policies are not claims made, they are occurrence. That means that there's a possibility that you could have a claim 15 years down the road, and you have a 15-year-old policy covering that. And that policy theoretically is changed by every single piece of document that the insurance carrier sends you. The amendments, the addendums, and all of that, and you need to keep copies of all of it. And that is something that you want to keep forever.
Any other questions?
Again, thank you for the opportunity.
Also, Denton, for your time and for all the preparation. So just a gift.
Thank you.
And Denton has given us also, like, each one the copy of Jeffrey's book. So it's actually a very good asset, and we didn't have to buy it, and this is really helpful for us. And so we would, hopefully everyone got some ideas. We have more things to talk when we're going to come on.
The idea of the book was that Sheldon actually asked the whole firm to help him write the book. He did most of it himself, but everybody chipped in editing it and whatnot. He set out to write a book that's shorter than 100 pages. He didn't quite make it. It was like 138. But the idea is that you could read it in one setting. For example, flying to Hong Kong, you could just read it from end to end, not for the purpose of memorizing, but at least knowing enough that you know when to call the lawyer.
Thank you.
And we have offered Stella another 100 copies of it. And do with it as you
some of
please.
our US offices. Thank you so much.
Thank you again.